We've sold about $150,000 worth of art to the Dane County public. We've had over 100 artists work with us. We have a number of creative artists working with us in terms of caterers and other various forms of the arts to bring what we initially wanted to be a fun market so that you can come and buy art and get artists to be aligned with more businesses. So thank you, Sarah, Olivia, and Adalia for helping coordinate this year. Ms. Russell's book, Arts, Laws, Conversations, this one right here, it's a sustainable, readable guide for arts entrepreneurs. It's a great, fun read. I've gone through it again this past week. I have it on my desk. It's a great reference manual for me. It has great resources, great advice, and great references that you can check when you go through the book and really get a better understanding, because we really need to empower ourselves greater with understanding the legal system here. And I wanted to thank Karen Wolf from the Madison Arts Commission. She gave me this book a couple of years ago. And again, I keep it on my desk as a reference. So thank you for joining with us. Be sure and sign up for the Dane Arts newsletter at danearts.com. Visit the market and see the rest of our schedule. We have very exciting activities coming up over the next several months. And we hope to have our Dane Arts Buy Local 2-day art market, October 1st and 2nd at Garver Feed Mill, as long as all of you continue to wear your mask and wash your hands and keep your distance. And thank you for joining us, Elizabeth Russell.
Well, hi, everybody. Thank you, Mark. Thank you, Sarah. Yeah, being here is wonderful and, of course, weird. We're all getting pretty used to weird. And maybe it won't be weird for forever. I've taught a number of classes on legal issues, particularly in the arts, and my experience has been I'll encounter a student either at the time or later, and they will say something to me that makes me wonder, did you have any idea what I was talking about? You know, I will have taught the thing, and I was like, what? You actually believe that? To the point where, and I'm not kidding about this, my thought about teaching is maybe it's doing, in this realm, is that maybe it's doing more harm than good, because it's difficult, it's so difficult to teach legal stuff in a way that's going to stick and that's going to be useful. And I'll be honest, I think my teaching in the past may have contributed to myths, because it's almost inevitable that misunderstandings were going to happen. So in my own mind, it's kind of funny. I had decided if I was ever asked, I know this isn't a class, but if I was ever asked to teach an actual class sometime, I said, you know what, I think I'm only going to teach the myths, because that's what sticks, and that's really what's most dangerous. So when DABL asked me to do this, I was like, all right, let's do it, man. Let's talk about just the myths and try to knock some away. So here's my plan. I am going to show you a slide that has a statement on it. And actually, before I say anything more, Sarah, is it true that we have people just on the phone?
We have one person on the phone that I can see.
Well, one is enough. So what I'm going to do, instead of just show it, is I will read it as well. And I hadn't planned on that, so I'm glad to know that. So I'm going to show you a slide, and it will have a statement on it. Then I'll pause for, I don't know, 5-6 seconds, so you can decide in your own mind if you think that statement is a myth or if it's true. And there will be some of both. Now, please listen to this, because I sincerely really mean this. Getting it wrong is a good thing, okay? So don't be embarrassed if you get it wrong, and no one's gonna know, because this is only gonna be in your own head, but still, answer for yourself. But get it wrong, that's good, because these things are myths precisely because lots of people believe them to be true. So the more you get wrong, actually the better, because that's getting it wrong, that's what you're going to remember. So also, I guess I'd like to get through them all. So my suggestion, we can do this however you want, but I suggest that you make a list of the particular statements that spark questions for you, and we can have a good discussion after I've gone through them all. That's my plan. If you think that's not working and we have to stop and talk right at the moment, so be it. We're nothing but flexible. So, you know, as for myths, I think our problem isn't that myths exist. Unto themselves, myths aren't necessarily bad, right? I mean, in literature, they're art. So as far as I'm concerned, go ahead and believe whatever myths you want. That's really not our concern. My concern is that you not act on them. Our problem in law is artists making actual business decisions based on beliefs, things they believe that are not accurate. It's acting. The problem is acting on these myths. So after tonight, you might or you might not remember everything we talked about. You might or might not still believe in certain myths. But what I hope you take away is the commitment to stop and get good advice whenever you have the slightest question about whether what you are about to do could possibly be based on bad information. That's the danger. So let's just talk about myths in general. Why do we have so many? One reason that there are so many myths in law is because, and this is unique to law, every legal decision depends on the facts of a particular circumstance. And the facts will never, ever be the same in any two situations. So, we good? You can see the screen now?
Yes.
Okay, yes is a good answer. All right, so let's say that just today you learned that the correct information is both arms extended. That's correct, but it's only correct for the facts you are facing today. The next time you encounter a sort of similar issue, it won't be exactly the same. The facts will be different. And trust me, the law can change dramatically when the facts change even just a tiny little bit. So next time, the correct information might or might not be both arms extended, or it might be close to that, but not exactly that. And if you haven't adjusted for the facts, though, you're likely to end up believing that both arms extended is the correct information in all situations, when it absolutely is not. And then you start telling others that the rule is both arms extended no matter what, and thank you, good job, you've now become the legal equivalent of an asymptomatic carrier. All right, so that's my view of how myths begin and spread. So no matter what the topic of a session or a workshop, I always show these next two slides because they are the foundation of every copyright discussion. The first, this is what types of work copyright protects. These are called the works of authorship, and copyright is only relevant if the type of work we're talking about is the types of work on this list. The second foundational issue is what you get with a copyright. This is called the bundle of rights. When you create work and when you get copyright, you don't get a single thing. You get this bundle of rights consisting of a right to reproduce the work, a right to prepare derivative works to make adaptations from the work, the right to distribute physical tangible copies of the work, the right to perform the work publicly, the right to display the work publicly, and then PISRDAT applies to something else we're not going to talk about today. But this is the bundle of rights, and I'll leave it there and now get to the myths, but do try to remember these two foundation slides because we will almost certainly be referring to them later. Okay. First statement, I will now read it out loud. I don't have any copyrights because I have not registered with the Copyright Office. Do you think that this is truth or myth? I will now count to 4 in my head because we already used up 2 seconds. This is a myth. I hear it often. People say, I don't have any copyrights. And I said, have you ever created anything? Well, of course. Well, then you do. You do not have to register with the United States Copyright Office to get this bundle of rights. See, there it is again already up in the corner. Copyright and registration are two totally separate things. Your copyright is that bundle of rights. And you get that bundle of rights the minute you created a work of authorship and you put it in some kind of fixed, tangible medium. So the minute you wrote words on paper, the minute you clicked the shutter and took the photograph, the minute you put paint on canvas, that bundle sprung up and it's yours and it's your copyright and every right in there is yours. It's completely separate from registering with the US Copyright Office. Now, registering with the Copyright Office is a fantastic thing to do, and I could talk to you all day about why that's good and why you get those benefits, but it's not the same thing as owning a copyright, right? So you already, as creators, have tons of copyrights, even if you never thought about it, and even if you haven't registered a single thing. Second statement, I'm not going to forget how many, so next statement. I can't sue anyone for infringement unless I have registered with the US Copyright Office. Do you think that that is true or a myth? That is absolutely true. And that is one of the reasons why registering with the Copyright Office is a nifty thing to do. Because here's the thing. You can't sue anybody unless you have that bundle of rights. You own the copyright, but you can't sue anybody unless you have a registration. So what I usually hear, the conversation goes like this. It's like, well, first of all, well, why should I register if I already own the copyright? And I just told you, because you can't sue anybody. And then next thing you're going to say is, I'm never actually going to sue anybody anyway. I know that will never happen. And then I say, I know that too, but you probably will want to call somebody out if they start using your work, and you probably will want to negotiate some kind of resolution with them, right? Like you're somehow, even short of suing them, you want to work it out and make them stop doing this, right? And you'll say, well, yeah, I want to do that. And the reason you want to have your registration is because your bargaining power in those discussions is, bottom line, the other person, the infringer, knows that you could sue them. That's your power. So anybody who knows anything, if you approach them and say, hey, you're using my work, knock it off, their first question is going to be, well, where's your registration? And if your answer is, I don't have one, they are going to laugh at you immediately and keep doing exactly what they're doing, because they know without that registration, you cannot sue them. So it's a really good idea to register. And you might say, well, I've got way too much stuff. We can talk about that another day, but you definitely want to register your golden eggs, or the things that you think are going to be, or that are being infringed. So that's my spiel on registration. Next statement. Mailing it to myself is an alternative to registering with the Copyright Office. I can't see you all right now, but I would love to see a show of hands of whoever has seen this before. This is one of the most widespread, yes, myths that's out there. I mean, mailing it to yourself, it might be an alternative, but it's a really bad alternative, because it accomplishes absolutely nothing, and you can't sue anybody with something that you mailed to yourself either. So I have no idea where this one started, but I can tell you that like a good percentage of everyone walking the earth believes this to be true, and it's not. Next statement. If I own the copyright, I can do whatever I want with the work. What do you think about this one? Man, I wish I could see your faces. All right. if I own the copyright, you'd think that would be true, right? Well, not really. And I'll tell you why. What we're looking at here, person on the phone, is a table that depicts intellectual property. Intellectual property is an umbrella. It's not a thing of its own. And what I would really, really like to extract from every one of you at this very moment is the pledge to never again in your life ever use the term intellectual property, ever, unless you're talking about all 5 of these things together. So what we see on the table are the 5 different types of intellectual property: copyright, trademark, the rights of privacy and publicity, patent, and trade secrets. They're all completely different areas of law, like apples, oranges, bananas, palm trees, scissors. I mean, they're not even related. But they are the 5 types of intellectual property. So let's go back to the statement. If I own the copyright, I can do whatever I want with the work. And I said that's a myth. Why? Because sure, that you can exercise all of the rights on your bundle of copyright rights. That's true. But that doesn't mean that whatever you plan to do with the work mightn't infringe somebody else's other type of rights. For example, if you your work is a piece of visual art, okay, fine, you own the copyright, you can exercise the bundle of rights. But what if that piece of visual art is somebody else's trademark now because of whatever deals you struck? You can't do anything you want ever. You always have to consider these other potential areas of law. And one that comes up a lot, privacy, is when when a human being's name or image appears in your work. That's not a copyright issue. You can do whatever you want with the copyright, but that doesn't mean that you can do whatever you want with your work if it depicts another person. Completely separate area of law that, again, we could have a separate session about. My point tonight is don't make these mistakes of thinking that just because you're cool on copyright, there might not be some other obstacles you need to consider. Next statement. If I paid for it to be created, I own the copyright to the work. What do you think? Myth or truth? Now, as artists, I hope you know that that is a complete myth. And the reason I put it in here is less to convince you and more to convince you to remember that you're going to have to educate your buyers, your commissioning parties, anybody that you're selling your work to. Because I can guarantee they don't know. You might know this, and as I said, I'm sure that you do know this, but most people out there in the world do not. The assumption is, amongst most people, if I paid you to make something, I own the copyright. So it's really up to you to educate them otherwise. And here's how you can do it. Here's the default rule. Right? Copyright vests in the author of the work. And in copyright law, author typically means the creator, the person who made the work, and that's you. So what's the default rule? You made it, you own the copyright, period. It doesn't, being paid to create it does not change that, except if the work happens to be what we call work made for hire. And I'm not kidding, except for fair use, work made for hire is the most misunderstood concept in all of copyright law. But it's true that if the work actually does qualify as work made for hire, okay, then you don't own the copyright, then the person who paid does. So I'm going to take like 2 minutes and explain work made for hire, just because we should, right? There's 2 ways that work can actually be made, can be considered work made for hire. One is if you're an employee. If you're an actual employee and you created the work in the course of your duties in your job, then fine, yes, it is work made for hire, and the employer is actually considered the author from the start. It's like you never existed, and the employer owns the copyright. That one's pretty clear cut if you're an employee. The other one, the other way work can be work made for hire, this is where all the confusion happens, is suppose somebody comes to you and hands you a contract and says, I am commissioning you to create this work, and it says right here in this contract, this is going to be work made for hire. If you sign that, is it work made for hire? It's usually not. It will only be work made for hire under that kind of circumstance if what you're creating is in one of these 9 weird categories. And I usually swear when I say that, but I know this will be viewed later, so I'm kind of proud that I just didn't swear. There are only 9 types of work for a commissioning situation that qualify as work made for hire. And most of what I'm guessing you do is not going to be that. Like if you're, for example, painting someone's portrait, that is not on this list. And for phone person, the 9 categories are contribution to a collective work, like if you write an article for a magazine, if you're doing work for a film, that can be work made for hire. But the others, the rest are really weird, doing and weirdly specific. So the others are creating a translation, a supplementary work, a compilation, an instructional text, a test, and separate category answer material for a test. We're getting very specific. And my personal favorite, an atlas. So unless you're doing one of these 9 weird things, it's not work made for hire, even if somebody gives you a contract and says it is. So that's where a lot of the misunderstanding happens. If somebody comes to you and they're commissioning you to create work, they want to own the copyright, work made for hire is not going to cut it. You're going to have to do a separate agreement called an assignment agreement, and that gets more complicated. My point again for tonight is it's really going to be up to you to educate your buyers and anyone paying you to create work, especially you graphic designers. This is where it happens a lot, about who actually owns the copyright, and usually the answer is going to be you and not them. Okay. Next statement. If I do business as an LLC, you could say, or corporation, doesn't matter, and I created the work, the LLC owns the copyright. What do you think about that? You're doing business through some kind of business entity. You created the work, then who owns the copyright, you or the entity? Well, let's just keep this simple and say that it's, you're a single person, like a single member LLC. This is and let's put aside that you're an employee. If you were an employee, that would be different, right? That's what we were just talking about. Let's say you're not an employee, you're just an owner. Well, man, do I see this a lot. The answer is no. Your LLC does not own the copyright. You personally own it. We just went through that. That's the default. The person who creates it owns it. It doesn't really matter that you're doing business through another entity. And this matters tons out in actual business, because if you haven't thought this through, your business can't be going out and exploiting this work that it doesn't own unless you have gone through these formalities of transferring it from you personally to the entity. And this is actually another example in a different context of where you could run into trouble. What people do their own copyright registrations, and in this example, you could maybe think, well, I want the LLC to own the copyright, so I think I'll just check this box here saying that you know, we'll make the LLC be the owner. Well, checking a box does not make it happen. And you could think that you were doing that properly, and you might get a registration back in your hands, but it would be invalid, and you wouldn't necessarily know that until some time came when you had to rely on it and use it. So here's the rule. And it's no different than if you were doing business with somebody else. If you created the work, you own the copyright. If you want even your own business to own it or to be able to exploit it, and so you have to go through all these formalities, even with yourself. I know that sounds weird, but I do this all the time with people, like agreements between individual person and person's business. I mean, they're like, oh, it's all me. I was like, I know, you still have to do this. Next statement. I can sell the copyright separately from the tangible work. Do you think that is true or a myth? Can you sell the copyright separate from the physical work itself? You absolutely can, and this is a really important concept. Your bundle of rights, the copyright, is a completely separate asset from the physical medium in which you embodied your expression. All right, I know that sounded confusing. I should use different words. Copyright is different from the thing. How's that? And you can dispose of the copyright by sale or gift or license or anything you want, and that is totally unrelated to getting rid of the thing. And here's a little tip too. If you're doing your estate planning, involve your copyright lawyer, because this is often done incorrectly. And it's, you know, I'm not knocking on the estate planning lawyers, but it's just not their thing. And they don't necessarily think this part of it through. They are completely separate assets. And here's another way of depicting it. On the thing, the physical medium, if I'm a purchaser, I bought a hunk of canvas, and that's one thing, but I did not, by purchasing that hunk of canvas, acquire any tiny little bit of your copyright and bundle of rights, right? Just always think that the copyright and the physical thing are separate assets, and you can dispose of them completely separately. Next statement. Copyright lasts for the life of the author plus 70 years. True or myth? Actual trick question, because that is true, but only sometimes. And the reason it's only sometimes is because there are tons of rules out there. A lot of what you create today will be subject to this rule, and it will last for your life plus 70 years. But there's a lot of other situations where a different period of time applies. And I'm not going to go into them right now, but my message is, if you're ever in a situation where it's important for you to figure out how long copyright is going to last, don't just assume it's always going to be life plus 70. You really need to look a little bit deeper into the circumstances and the facts and decide if does the life plus 70 year apply, or does one of these other rules apply. So just tuck that away. Here's my favorite. If I don't care what you say, anything fill in the blank, it's fair use. And I'm just going to tell you flat out, that's a myth. If anybody says to you ever, if this, it's fair use, that's not true, because this is the greatest example of facts changing the results. It is legally impossible to make a determination on fair use separate from the precise facts that you are facing at that time. There is no bright line rule. There's no black and white rule. You can't legally say that well, I know this, so that therefore it's fair use. You must always have a fact-specific analysis. And I know you hate that, and I don't love it myself, but it's the way it is. And the quickest way to get in trouble is for you to make any assumption ever in life that something is fair use. I'll just say it again, I know I just did. There is no way to conclude that anything is fair use unless you go through a complete legal analysis. Okay, that's enough on that. Next statement. It's okay to use somebody else's copyrighted work if I'm not making money. No, that is not true. If you are infringing on any aspect of somebody else's bundle of rights, it's irrelevant whether you are making money in the course of doing so or not. I could be infringing on your work and it could never leave my basement and I still committed infringement. These last few are really fast, but it's okay to use somebody else's work if I'm a nonprofit. Let's just say no, you're the same as everybody else, nonprofits. It's okay if I use somebody else's copyrighted work if I'm using it for educational purposes. No. There are some specific exceptions in the copyright statutes that apply to certain types of educational institutions. Okay, that is true, but they're very, very narrow. So the danger here is schools or teachers, students themselves, just thinking you have a free pass because what you're doing is in the context of school. That's a huge danger. So that's why I put it on the list tonight. It's okay. Here's a famous one. It's okay to use somebody else's copyrighted work if I change it by, they usually say 10%, or if I only use a certain number of words. No, there is no bright line rule about this either. And man, I hear this one a lot, but that's not true. Both that and the educational one actually, and the nonprofit one, all of them go back to fair use. There are certain circumstances under which a use might be fair use, and sometimes commercial or not commercial use figures into it. Sometimes educational use figures into it. Sometimes the amount you use figures into it, but they are not the only factors. You have to do a complete legal analysis for fair use. None of these bright lines are going to bail you out. Next statement, it's the next to last statement actually. If something has been widely disseminated without restrictions, it's in the public domain. No. And this is a dangerous one. I hear this pretty often as well. Like, well, it is everywhere. That photo is everywhere. It's on every platform. It's on every medium. It's got to be public domain. It's not just because something's out there does not make it public domain. Copyrights don't go away. Sometimes their owners might choose to enforce or not enforce them, but that doesn't mean they aren't there. Just because you see something out there doesn't mean it's okay to use. And finally, I can do whatever I want with royalty-free materials. This is a real danger. Oh, surprise, that's a myth. Royalty-free means you don't have to pay money. That's all it means. It doesn't mean there aren't really significant license restrictions. And this applies to Creative Commons materials. It applies to stock materials. Creative Commons, if you look deep enough, has a lengthy license provision. I mean, like pages worth of legal language. Stock material has even lengthier licensing provisions. There are always licensing terms that you must observe when you're using these types of materials. Even if you don't have to pay money, there's always rules. And if you violate those rules, the other word for that is copyright infringement, is also breach of contract. So don't make the mistake of thinking that as long as it says stock or royalty free, that you're cool and you can do whatever you want, because that is a minefield. I was once called into a deal where a bank was being sold, and I'm not kidding you, the deal did not happen because they had made this mistake. The bank that was being acquired had put images on its website that they thought were fine to use because they were royalty free, and they were in breach of licensing agreements, and that made the bank acquisition not happen. So don't let this happen to you, especially when you're selling your bank the next time. All right, that's all I've got. I'm gonna stop sharing my screen and let you talk if you want to. If there were any particular statements that we talked about that sparked a flame for you, we can talk about whatever you'd like.
There's a question in the chat if we want to just start with that right away.
All righty.
The question is, or the statement really is, please explain concept and examples of public domain.
All righty. Copyright lasts for a finite period of time. We talked about that. A lot of times it's like the life of the author plus 70 years, but it doesn't matter. It's all copyright ends after a certain period of time. Once that time is up, that is when work falls into the public domain. That's it. That's the only way copyright work that has ever been subject to copyright can fall into the public domain. It's when that period of time expires. And that's it. That's the answer. So anything else, like I see it all the time, I see it here, they said it's free, anything else is just a generous license. Even things that have been like dedicated to Creative Commons, that doesn't mean there's no copyright. It doesn't mean it's in the public domain. It means the copyright owner has chosen to grant a very generous license, or maybe will even choose not to enforce it at all. But that didn't make copyright go away, and public domain means there is no more copyright protection at all. How does the idea of parity affect copyright? Well, parity usually comes up in the context of fair use. And as I said, there's quite an analysis we have to go through to assess whether fair use does or does not apply. Let's just say we did that, right? A lot of times people say, but isn't it fair use because it's parity? And that answer is no. Sometimes parity can tip the balance one way or another when we're engaging in a fair use analysis. But just because it is parity doesn't make it fair use. How binding is a verbal agreement versus written? Well, binding is a yes or no question. So it either is binding or it is not. But what I think you're getting at is when do contracts have to be in writing and when can they be verbal? And that's a great question because in some circumstances you can easily make a binding contract just in a conversation. The elements of a contract are well, legally, they're offer, you made an offer, acceptance, the other person accepted that offer, and there was some kind of exchange of an obligation on both sides. You can do that easily verbally, right? You'll say, like, forget it, I'm not going to come up with an example, but let's say you did it verbally. it's completely enforceable. But suppose you had to actually enforce it and you were in a dispute, it would be much easier to prove it if you had it in writing. So it's a good, that's one good reason why writing is better. There are certain types of contracts that actually have to be in writing, that can't be done verbally, and that's usually contracts that varies from state to state. Usually it's like for the sale of goods over X number of dollars, like $5,000, it's got to be in writing. Things like wills and real estate, they have to be in writing. So that's my sort of short answer. Is that good enough?
Yeah, I think so. Remember, for anybody that's listening, you can feel free to just chat the question here, or you can send it to me and I can relay the message. Looks like we have another question in the chat from Dave. Can notes from a verbal agreement be used to help support a verbal contract?
Yeah, that's what I was just saying. Thanks, Dave.
That clarification.
Does my advice apply? Yeah, everything we've talked about tonight certainly spans all disciplines artistically. I mean, honestly, it's not even limited to the arts. Everything I've been describing tonight applies to everyone walking the earth.
So musicians that play music from well-known artists at festivals and events need to have permission from those, from the artists who created that work?
Well, they do. Remember, imagine, if you will, the bundle of rights, and that fourth little spoke on the bundle is called the exclusive right of public performance. So if my band is playing at a festival, I can't perform your song without a license from you. That's part of your copyright as the composer of that musical work.
So what about in work I've done, I've hired artists to create images for another organization. The organization then wanted to use those images for another nonprofit as a auction item to raise money for that nonprofit. Does that artist then still contain the rights of those images, or has it become the ownership?
I don't know the details of the situation, but let's pretend I do, and say that organization number one purchased the hunk of canvas. So, and you can, if you purchase that hunk of canvas, you can pretty much do whatever you want with it once you've purchased it. So yeah, you could auction that off. That doesn't have anything to do with the artist's bundle of rights and copyright, which the artist retains.
So should the artist be paid? Should there be a negotiation of paying the artist for that image that's going to be auctioned off?
That's bringing up the controversial question of resale rights for resale royalties for artists, which do not exist in the United States. They existed in California up to a while, and then it was found unconstitutional. But no state in the U.S. has resale royalty provisions for artists. They do in Europe, so move there, I guess.
So the artist doesn't have the resale rights to the image.
No.
That was created. Okay.
No. Once you sold the first tangible item, that's out of your hands. The only thing analogous to any of this is the Visual Artists' Rights Act, which does provide artists with certain rights regarding their attribution and destruction and mutilation of their work later. That's a different area of law, but it's the closest one to what we might be talking about.
I'm going to ask for clarification on this. Let's say, because I'm seeing this could be two different ways and I'm not sure I'm understanding. Let's say somebody sells a item on a canvas to this business number one. Business
Yeah.
number 2 can then decide to donate that for the auction for business number 2. That makes sense to me.
Wait, how did business number 2 even get it in the first place?
Business number 1 decided to donate it to them for use in their
Okay,
auction,
gotcha. Okay.
or sell it to them for their use in their auction. But there's my main point being the physical canvas item is what's changing hands.
Correct.
Now, what if business 1 had purchased an image that was, for whatever reason, only an online image? And I guess I'm thinking of a friend who does these little almost cartoons, but he does all of his drawing on the computer. So there's no, he could print it out, but it's basically a computer generated item. So let's say he says to business 1, yes, I'm selling you, you have the right to use this on your website, for example. And it's a really cool image. Now, can business number 1 then somehow say to business number 2, oh, okay, we're gonna, for example, print this out onto a
No,
audio
because
canvas?
we've just
Is this getting way too obscure?
Well, no, but we've just abandoned the idea of a hunk of canvas. So we're talking about something totally different now. If we're talking about an online image and the artist said to business number 1, you can use this on your website, there is no hunk of canvas. That's like a reproduction license for a very specific use on the website. And all that business number 1 acquired was the right to do that one specific thing. That's a license. That's not ownership of anything.
Okay, and that's what I was trying to figure out, is if those were really treated completely like separate things, and it sounds like. So whether it's a physical item or a image on the computer. So thank you for clarifying that for me.
Sure. If you see your work being used without permission, what should you do? Well, the first thing you should do, everyone, is go get that copyright registration out of the drawer, right? The second thing you should do, if you didn't have one, is maybe go get a copyright registration for the thing that's being used without permission. The third thing you should do, and if you found it being used online, our actual discussion is about the Digital Millennium Copyright Act DMCA takedown procedures. And if you don't know what I'm talking about, go to any platform, like go to YouTube or Google or any of them, and just put in the search bar platform name and then DMCA policy, and you will see exactly what I'm talking about. Every platform has a procedure where if you find your work online, you follow the procedure and they will probably take it down. Why? Because if they don't, they are just as liable as the infringer. And this is a procedure that gives them, the platform, safe harbor. Now, here's so the answer is probably do a DMCA takedown request, but stop in your tracks before doing so, because the flip side of this is, yes, the law gives you this chance, this opportunity, but it also requires that before you submit that kind of takedown request, you have to swear that you have conducted a fair use analysis and concluded that the person that put your work up there doesn't have any legitimate reason for doing so, and that it isn't fair use. And if you haven't done that and you just willy-nilly slap up DMCA takedowns, then that can come back and bite you, because there are penalties for not first having conducted that fair use analysis. So the answer is the DMCA procedure is a tool, but it's a tool that you must use carefully, not unlike a table saw. Okay. When something is registered retroactively for copyright, when does copyright take effect? Upon registration, or okay, copyright creation takes effect on creation, but the registration isn't going to be, your registration date will be the date that the Copyright Office received three things: your application, the fee, and a deposit copy of exactly what's being registered. On that date, when they have all three things, that's the effective date of your registration. And the effective date of registration matters a lot in litigation and damages. So you want that date to be as early as possible, ideally. How do logos fit into this discussion? Assuming you hire someone to design it and for electronic and print use. Well, a logo, we could use a logo as an example for pretty much anything we've talked about tonight. The one that comes to mind, I'm sounding a little bit like a broken record though, is the who owns it if I paid for it thing. Because man, does that happen a lot with logos. But really, you know, I said before, does this apply across all artistic disciplines? Yeah, absolutely. Logos are no exceptions. The only different thing with logo is that they usually turn into being somebody else's trademark. So yeah, so use wise, we usually have to start putting the trademark hat on as well as the copyright. How do you do a fair use analysis? Wow, look at the time. I think it's about up.
Dodging a question.
That it's a great question, and you know, am I going to dodge it? Absolutely. That's one that we're gonna. We could do that in a separate session and maybe be useful, but not tonight. Sorry about that.
No worries. I think we probably have space for about one more question. Let's see. There was a good one in here about original artists and the legal obligation. Perhaps you already answered that one. Did you already answer that if you're a business that's purchasing and reselling licensed reproductions, do you have any legal obligation to the original artist?
Well, I didn't see that one directly, but we were just kind of talking about the resale royalties and how there is no right of that.
Okay.
So the answer to that is, unless I'm really misunderstanding it, which is always a possibility, no, you do not.
Okay. Then perhaps let's do this last one, still about DMCA. How does it work with Pinterest?
Exactly the same as any other platform. Just go enter, just look for, I would just go to regular Google and just enter Pinterest and DMCA. And if the procedure doesn't pop up right away, go back and try again. And instead of saying DMCA, just say copyright or copyright complaint policy or something like that, and you will pretty quickly be led to what the procedure. But the fact that it's Pinterest as opposed to any other platform doesn't matter. They're all the same.
Gotcha. Thank you. I'm going to drop a link to your book in the chat if you want to just give us a couple words about it, and then I'll send it over to Mark to finish this out.
We can send it to Mark now.
Okay. Well, Elizabeth, thank you so much.
This is a great thing.
Right.
Thank you so much, Elizabeth. What a wonderful presentation. So fun. And it's so great to have fun on a presentation about such important work as copyright law and rights of artists. And most artists really need to do a better job as owning their work and understanding it. And I know it's a lot of work. That's why Dane Arts is here to help you with any of that kind of work. I think we'd welcome another workshop with Elizabeth to further go deeper into this. I'm also going to extend Dane Arts' opportunity to perhaps help you connect with Elizabeth with legal issues. If we need to employ Elizabeth to help you legally, I think Dane Arts is going to take a risk at maybe there's an opportunity to do so, so that we can help all individual artists. I'm not saying it's a guarantee, but I'd really like to have Elizabeth available to all these individual artists in Dane County who may have a need for additional information that they may not, in this pandemic especially, have the funds to afford that. I don't know how much money I'll be able to put forward, but if you have some real serious issues or you're in the middle of some kind of legal issue and you need some immediate help, I think Dana is going to put its foot forward to see how we can do to help you afford that cost to meet with Elizabeth on a private session. Thank you so much for your time. I really hope we do this again. I appreciate all of you being here this evening. This has really been a wonderful exploration on copyright laws, very fun. So make sure you go to dabblemarket.com to look at the remaining sessions, all very informative. We have music, we have a lot of activities over the next couple months. We hope to have the market October 1st and 2nd. Go to danearts.com and please don't ever hesitate to come to Dane Arts for any kind of situation in which you need some support, whether it's administrative, management, strategic planning. We are here to help you, and DABL Market was established as an effort to help individual artists across disciplines become better artists and understand the business of art and the art of business. So thank you all for being with us this evening.
Thanks, Mark. And if you missed any portion of this, we will have the recording available on our website, dabblemarket.com, DABL market.com.
7 o'clock.